On the evening of June 29, 1892, in the coastal town of Necochea, Argentina, a woman named Francisca Rojas ran out of her house screaming that her children had been killed. Inside, her 2 children were dead. Rojas had a shallow knife wound across her throat. She named her neighbor immediately, Pedro Ramon Velázquez. He had tried to court her. She had refused him. He had come back with a knife. Local police arrested Velázquez the same night. He denied everything. He had been out with friends. He had witnesses. The police did not consider his witnesses particularly relevant. What they had was a woman with a wound on her throat and a name on her lips. And in the courts of 19th century Argentina, that was a considerable amount of evidence. So they applied pressure. They tied Velázquez to the corpses of the children overnight. When that produced no confession, they tortured him for a week. He maintained his innocence throughout. He had an alibi. He had his own word. But he had nothing that could place the guilt somewhere else. No mark, no physical trace. Nothing he could point to and say, "This was left by the person who did this, and that person is not me." Before fingerprints, how did anyone prove who committed a crime? The answer runs through 3 systems. The first ran entirely on word, on who named you and who would speak for you. The second tried to replace word with measurement, and nearly succeeded. And the third arrived on a section of wooden door in that house in Necochea, before anyone outside one small Argentine identification office understood what it meant. The first system is the one that governed criminal identity for centuries, and it was exactly as fragile as Velázquez's situation suggests. In a magistrate's court in 17th or 18th century England, France, or colonial America, the question of who you were and what your moral character was would be answered by the people who knew you. Neighbors testified, employers testified, parish clergy testified. The character witness was not supplementary to a trial. In many cases, it was the primary evidentiary framework. A man of known good standing in his community, accused by a stranger, had a real chance of walking out. A stranger accused by someone with local standing, with no one in the courtroom who could speak for him, had only his word. And his word meant nothing in a room where nobody knew whose word it was. Medieval English law formalized this in a practice called compurgation. An accused person in a courthouse in medieval London was required to produce a specified number of oath helpers, community members willing to swear on their own honor that the accused was honest and that his denial should be believed. Fail to produce them, and you were presumed guilty. The logic was that your neighbors collectively held your identity on your behalf, that your moral character was a social asset verified by people who had observed it over years. If you had built those relationships, the system could protect you. If you had not, it had no way to reach you at all. Courts in ancient Babylon, medieval Europe, and colonial Boston arrived independently at this same arrangement without contact with each other, which tells you how universal the problem was. In every society complex enough to have strangers passing through it, identity had to be vouched for by people who already knew you. The system worked for people embedded in stable communities. It failed catastrophically for anyone who was a migrant laborer, a traveler, a freed slave with no local connections, or simply anyone unlucky enough to be accused by someone with better standing and more friends in the room. And it failed in a second direction entirely. Courts in a sheriff's office in colonial Boston or a provincial courthouse in 19th century France had no reliable way to establish whether the person standing before them had appeared before a court before. Criminal records, to the extent they existed, were handwritten entries in local ledgers that did not travel between jurisdictions. A man convicted of robbery in Liverpool could move to Manchester, give a different name, and present himself as a man of entirely clean record. New York State's prison department in 1893 described the scale of the problem precisely. There was simply no accurate way to identify recidivists, and too many hardened criminals were being sentenced as if they had never stood before a court in their lives. For the falsely accused, the danger ran in the opposite direction with equal force. If you were a stranger, and someone with local standing pointed at you in a courtroom in 19th century Paris, there was no systematic way for a court to go beyond that accusation. There were no crime scene procedures worth the name. There were no scientific methods for establishing who had been present at a scene. There was witness testimony, and there was the confession that sometimes followed from pressure applied to a suspect who refused to cooperate. Velasquez had friends who would confirm his whereabouts. He had an alibi that investigators, when they looked at it honestly, found credible. None of it reached the threshold of making his word count against the word of a wounded woman whose children were dead on a bed behind her. The system had no next step. It could not ask the physical world what it had witnessed. That next step came from a records clerk named Alphonse Bertillon, and the system he built between 1879 and 1883 in the identification office of the Paris Police Department was, at the time of its introduction, the most sophisticated tool for criminal identity the world had ever seen. Bertillon was placed in the Paris police through his father's professional connections after a series of failed attempts at other careers. He was reportedly difficult, obsessive, and thoroughly convinced that the filing system around him was a professional embarrassment, which it largely was. The identification records in the late 1870s were a mass of inconsistent handwritten descriptions and unorganized photographs that made it practically impossible to establish whether a person in custody had ever been processed by the system before. His solution was to replace word with measurement. He drew on anthropological research, establishing that certain bony measurements of adult human bodies remain stable from the late teens onward and do not change through the rest of a person's life. He built a classification system around 11 such measurements, including the length and width of the skull, the length of the left foot and middle finger, standing height, sitting height, and arm span. These were recorded on a standardized card alongside two photographs taken at fixed angles, one frontal and one profile, in the identification room at the Préfecture de Police in Paris. This standardized two-photograph arrest record is where the modern mugshot originates. Also noted on the card were distinctive features, scars, tattoos, eye color graded against a reference chart, the shape of the nose, any deformities. By cross-referencing measurements with descriptors, Bertillon could place any individual into one of 1,701 separate filing categories, reducing any new set of measurements to a pile small enough for a trained examiner to search in minutes. In 1884, 1 year after the Paris police formally adopted the system, Bertillon used his files to identify 241 recidivist criminals who had presented themselves under false names on arrest. The demonstration was persuasive enough that Bertillonage was adopted by police forces across Britain, Europe, and the Americas within a decade. New York State's prison department sent its chief clerk, Charles K. Baker, to the Identification Bureau in Paris in 1893 specifically to study and import the system. For the first time in recorded history, any individual once properly classified could theoretically be tracked across time and geography, even if they changed their name or moved to another jurisdiction entirely. The word of a community was no longer the only way to establish who someone was. It worked, for the majority of cases it handled, across 2 decades of widespread use. The problem was that it worked on approximations, and approximations have a limit that Bertillon's own mathematics did not fully account for. The measurement tools required constant recalibration. Even well-trained officers at the Leavenworth prison in Kansas or the identification bureaus of London produced different readings for the same person, measured on different occasions, because human bodies are not perfectly symmetric, and instruments respond to how much pressure is applied and at what angle. The three-category classification collapsed real physical differences into fewer distinguishable outcomes than Bertillon's statistics implied, and the entire architecture rested on the assumption that no two adults would share the same combination of 11 measurements. That assumption held statistically in the aggregate. It failed specifically in Kansas in 1903. When a man named Will West arrived at the United States Penitentiary in Leavenworth that May, the records clerk ran the Bertillon instruments over him and then searched the files. The measurements matched almost exactly with a card already in the system. The photographs on the card were indistinguishable from the face of the man sitting across the desk. The name on the card was William West. The clerk informed the new arrival that he was apparently already at Leavenworth, serving a life sentence for murder. Will West said he had never been to Leavenworth in his life. He was telling the truth. William West, a different man with the same name, the same measurements, and a face that photographs could not separate from Will West's, was at that moment in a cell in the same building. The warden, according to accounts of the incident, declared that this was the death of Bertillonage. The prison began fingerprinting all inmates the following year. Bertillonage had also been calibrated entirely on adult males with short hair, which made it unreliable for women, for children, and for anyone whose body was still developing. For a method claiming to establish universal criminal identity, this was a substantial portion of the population to exclude by design. What the Will West case made visible was not a failure of effort. It was a failure of the underlying premise. Any system built on physical approximation will eventually find two people whose approximations match. Bertillon had tried to replace the word of a community with the authority of measurement. But a measurement that collapses into three categories, taken by a human being with an instrument that needs recalibration, is not as different from a rumor as it appears from a distance. 11 years before Will West walked into Leavenworth, in a house in Necochea, the answer to the problem had already been used to free an innocent man and convict a guilty one. Juan Vucetich was a Croatian immigrant who had arrived in Argentina in 1882 at the age of 24 and found work with the police in La Plata. In 1891, the chief of police of Buenos Aires province instructed him to establish an identification office. Vucetich began with Bertillonage as expected, but that same year he encountered an article in the French journal Revue Scientifique describing the work of British anthropologist Francis Galton on the ridge patterns of human fingertips. Galton had established that the patterns of loops, whorls, and arches in the friction ridge skin of a fingertip are unique to each individual and permanent from birth to death, unchanged by age or injury. He had calculated the probability of any two individuals sharing the same fingerprint pattern at approximately 1 in 64 billion. Vucetich began collecting inked fingerprint impressions from arrested persons alongside his Bertillon measurements. By the end of 1891, he had established the world's first fingerprint police bureau in La Plata and developed his own classification system, which he called dactyloscopia. He sorted fingerprints into 4 categories based on pattern type, assigned letters and numbers to each finger in sequence, and generated a formula for each person that placed their complete fingerprint record into a searchable file. No court in the world had yet used it to convict anyone of anything. The test came when word of the murders in Necochea reached La Plata on July 8th. Inspector Eduardo Alvarez, one of the officers Vucetich had personally trained, was dispatched to investigate. Local police had already been holding Velázquez for over a week, with no evidence beyond Rojas's accusation. When Alvarez arrived and examined the crime scene at the house on Calle Brown in Necochea, which was by then several days old, he found on the whitewashed doorpost of the children's bedroom a brown mark he recognized as a bloody thumbprint. He removed the section of doorpost bearing the print and brought it back to the Identification Bureau in La Plata. Vucetich compared the print from the door against inked impressions taken from both Velázquez and Rojas. Velasquez's fingers produced no match. Rojas's right thumb matched the doorpost print exactly, ridge for ridge, at every point of comparison. Rojas had previously insisted to police that she had not touched the children's bodies. When Alvarez confronted her with the comparison at the police station in Necochea, she broke down and confessed immediately. She had killed her children because a new suitor had told people he would marry her if not for them. The wound on her throat was self-inflicted. Velasquez was released. The mechanism that freed him was not a witness. It was not measurement taken by an officer with a calibrated instrument. It was a mark left by physical contact alone, at the moment of the crime, requiring no cooperation from any person afterward, and no authority to vouch for its authenticity. It could not be altered by changing a name. It could not be produced by anyone other than the person whose hand had touched that surface. The print was there because Rojas's right thumb had pressed against that particular piece of wood, and no other thumb in the world could leave that particular arrangement of ridges in that particular sequence. In England, Francis Galton's 1892 book Fingerprints provided the mathematical framework that made a full classification system possible. Sir Edward Henry, then Inspector General of the Bengali Police in India, built on Galton's work through the 1890s to develop the Henry classification system, which assigned numerical values to fingerprint patterns across all 10 fingers and sorted records into 1,024 primary groupings, each resting on a marker that was genuinely unique rather than merely probably unique. In 1901, Scotland Yard formally adopted the Henry classification system and established its Fingerprint Bureau in London. Argentina adopted fingerprinting as the sole method of criminal identification that same year. The Will West case in 1903 accelerated the American transition. In 1910, a man named Thomas Jennings left 4 fingerprints on the freshly painted porch railings of a house on West Washtenaw Avenue in Chicago during a burglary that ended in the murder of the homeowner, Clarence Hiller. At Jennings's November 1910 trial at the Cook County Criminal Court, 4 expert witnesses testified to what the prints showed, including the head of the Chicago Police Department's Bureau of Investigation and Mary Holland, the first woman to serve as a fingerprinting instructor in the United States. Jennings was convicted. His lawyers appealed, challenging both the admissibility of fingerprint evidence and the status of fingerprint examiners as expert witnesses. On December 21, 1911, the Illinois Supreme Court upheld the conviction, ruling that fingerprinting was a legitimate science and that expert testimony on it met the standard for admissibility. People v. Jennings established the legal foundation for fingerprint evidence across the United States. Thomas Jennings was hanged in February 1912, the first person in American legal history to be convicted on fingerprint evidence, a man who had left the mark of his own hand at the scene and had no argument against it. Here is the part of this history that almost no account of the fingerprint transition includes, and it matters more than any of the cases that came before it. The danger was never simply the absence of good evidence. The danger was that systems claiming to provide good evidence could be put in service of a conclusion that had already been reached. And the man who proved this most conclusively was Alphonse Bertillon himself. In October 1894, a French army captain named Alfred Dreyfus was arrested on charges of passing military secrets to Germany. The primary evidence against him was a handwritten memo retrieved from a wastebasket at the German embassy in Paris, known as the bordereau. French military intelligence needed a suspect. They fixed on Dreyfus. He was Jewish at a time when anti-Semitism in the officer corps of the French army was not a marginal attitude, but an institutional one, and he was the only Jewish officer on the general staff. The handwriting experts brought in first could not confirm that the bordereau was Dreyfus's work. The prosecution then called Bertillon. By 1894, He was the most famous scientific identification expert in France, possibly in the Western world. He was not a handwriting expert. He had, remarkably, stated publicly before this case that handwriting contained nothing unique to an individual and was worthless as a means of identification. He accepted the commission anyway. Bertillon examined the bordereau and produced a theory he called auto-forgery. His argument was that Dreyfus had deliberately copied his own handwriting as if a different person were producing it, so that if the document were identified as resembling his writing, he could claim it was a forgery. He used a complex series of measurements and probability calculations to argue that the specific similarities between the bordereau and Dreyfus's known handwriting samples were so numerous and so precise that they could not be coincidental. Both courts-martial in 1894 and again in 1899 accepted this testimony as significant evidence. Dreyfus was convicted on both occasions. He was stripped of his rank in a public ceremony at the École Militaire in Paris and transported to Devil's Island, the French penal colony off the coast of South America, where he spent 4 years in solitary confinement under permanent armed guard. Journalists and lawyers forced a re-examination of the case, aided by the writer Émile Zola, whose open letter accusing the military of a deliberate cover-up became one of the most famous documents in French political history. In 1904, the French government commissioned a review of Bertillon's analysis by 3 of France's leading mathematicians, Henri Poincaré, Jean-Gaston Darboux, and Paul-Émile Appel. Their report concluded that Bertillon's system was entirely devoid of scientific value, that he had failed to apply his own method correctly, and that his data could not be meaningfully evaluated by any recognizable standard of mathematical reasoning. The theory of auto-forgery was not merely wrong, it was not coherent enough to be wrong in a useful sense. Alfred Dreyfus was fully acquitted in 1906, 12 years after his arrest. The parallel with Velázquez is the part history rarely makes explicit. Velázquez was nearly destroyed by the word of a woman whose accusation was the available evidence and whose word happened to be false. Dreyfus was destroyed by the word of a man whose scientific reputation was the evidence and whose theory happened to be incoherent. The mechanism in both cases is identical, a confident assertion substituted for investigation. The person with authority to speak was believed because of who they were and how they spoke, not because what they said could be tested against something that existed independently of their own credibility. The difference between a rumor and an expert opinion is, when neither can be checked against physical evidence, much thinner than it appears. Bertillon had spent his entire career arguing that identity built on word and reputation was dangerously unreliable. In the courtroom where Alfred Dreyfus was convicted, Bertillon produced a pseudo-scientific theory in service of a pre-formed conclusion, and it was indistinguishable in its effect from the worst kind of character testimony the old system had ever generated. The court could not tell the difference because it lacked the tools to evaluate the claim independently of the man making it. Those tools arrived in 1904 in the form of 3 mathematicians, and they reversed the verdict that the absence of such tools had made possible. What fingerprinting changed was not that it made false accusation impossible. What it changed was that it introduced a category of evidence tied to the physical act itself, evidence that did not pass through any human word between the moment of the crime and the moment of evaluation. The mark on the door in Necochea did not require Rojas to confess. It did not require a witness to place her at the scene. It did not require a community to vouch for her or a mathematician to reverse an expert's theory. It was there because her hand had pressed against that particular surface. And no other hand in the world could have left that particular arrangement of ridges. That is a qualitatively different kind of evidence from anything that came before it. Not perfect, not incapable of misuse, but different in kind, not just in degree. The history of criminal identification before fingerprints is really the history of word. The first system ran entirely on it. The word of your neighbors, your employer, your priest, passed to a magistrate in a courtroom. It worked if you had people willing to speak for you and failed everyone who did not. The second system tried to replace word with numbers, and for 20 years it was convincing enough that courts and prisons across 2 continents adopted it. What the United States Penitentiary at Leavenworth proved in 1903 was that numbers taken by human hands from human bodies were still, in the end, a kind of word, an approximation, a judgment call. A system that required someone to decide what they saw. The third system took word out of the equation entirely. The print did not require interpretation. It required comparison. If you had been Ramon Velasquez in a cell in Necochea in July 1892, with a week of torture behind you and the word of a woman who had cut her own throat to make her story more convincing standing between you and the gallows, what evidence would you have wanted to exist that did not yet exist? That question, in different forms, was asked by every innocent person who stood before a court in the centuries before fingerprinting. The answer was always the same. Something that does not need a witness, something that cannot be falsified by a name or a reputation or an expert with a theory, something left at the moment of the act, by the act itself that carries no word from anyone. What had existed instead, for most of recorded history, was only someone's word. On September 20th, 1894, Francisca Rojas was convicted of the murders of her children and sentenced to life imprisonment at the prison in Buenos Aires. The bloody thumbprint on the whitewashed doorpost of the children's bedroom, the section of wood that Inspector Alvarez removed and transported to the Identification Bureau in La Plata, is preserved in the archives of the Buenos Aires Provincial Police. The print is still there. It has been there for over 130 years. It does not require anyone to speak for it. Ramon Velasquez's name does not appear in any document after his release from the police station in Necochea. He walked out and disappeared into the kind of anonymity that for most of human history was the only protection an innocent person had. No word, no record, no mark left anywhere that anyone could find. Which of these 3 systems do you think failed the most people? The reputation system, where your neighbors decided your fate. The Bertillon system, where a measurement error could put an innocent man in Leavenworth, or the era before fingerprints ended, when an expert's word could send Alfred Dreyfus to a cage on an island for 12 years? Leave your answer below. If you enjoyed spending 30 minutes inside this question, you know where to find the subscribe button. See you in the next one.